to go?
He is? Yeah, he's in Greece right now.
Ready?
He's in Greece for
Yeah, John got me some coffee. Yeah, and Kevin got you a Coke. Sugar and caffeine, you ought to be good. Good to go? Okay. Folks, could I have your attention? We'll come back to order here on our docket that we've been discussing. We are now down to the portion of questioning of the applicant and those opposing the application by the commission. And commissioners, we have 30 minutes. Anybody have any questions for either the applicant or the two gentlemen that have testified in opposition? Mr. Finney.
This is a question for the applicant. Have there been any recent traffic studies done on Highway 1694 and Chamberlain Lane as they access either going toward Highway 22 or going back into Oldham County to Highway 329?
I'm not aware of any. I mean, what happened is there was a traffic study, and then we built capacity for Norton Commons, and based upon the approvals from the state. So that's how there was a widening of 1694. There was a widening there at 22 that took place that my client participated in. But I don't think there's been a recent traffic study, no, sir.
Where Highway 1694 is widened, how wide is it when it crosses over I-71?
Two lanes. It's 2 lanes.
2 lanes. So even though it's widened, there's still just 2 lanes there. How wide is Chamberlain Lane when it passes under
2 lanes.
71?
2 lanes, yes, sir.
2 lanes. So no matter how wide 1694 is widened from 71 back in toward Oldham County, or Chamberlain Lane is widened either way, you still only have effective 2 lanes of traffic flow.
Yes, sir, and I know 1694 is a state highway, so that was approved by them. And when the traffic studies were done, the roads were sized at the intersections based upon a full build out of Norton Commons.
Okay. I can't say anything else because it's testimony. Thank you.
Okay. Any additional questions for either the applicant or two gentlemen that have testified? Oh, I'm sorry, Mr. Rick Williams. Go ahead.
Caught me with my mouth full of candy. Mr. Chairman, I couldn't begin to keep up with Bob McAuliffe and the different things that he was saying. I was writing as fast as I possibly could, but I couldn't keep up with him. So I was checking my notes, but he had made reference to that we had missed, we being the commission, had missed some deadlines or allowed deadlines or whatever to pass. Mr. Urban, did you?
Well, there are expiration dates both for PUDs as well as for development plans and the phasing. And I'm not going to pull the right date out of my brain, but
Sure.
Back in 2012 or thereabouts, maybe 2013, when we kept seeing, the Planning Commission kept seeing undeveloped, approved but undeveloped plans coming towards expiration, the applicants would come running into the Planning Commission and ask for extensions. So the Planning Commission developed a policy, and let me just put it, and I might correct myself, in January of 2012, and they said for the next 2 years, the staff can offer those extensions. And that, in my opinion, was across the board for any development plan because the economy had basically stalled, and we were going to keep seeing people come in for these revisions or these extensions. And then there had been a subsequent, 2 years later, the Planning Commission said, yeah, staff should keep reviewing extensions of the expiration, in which case we come as a matter of other business and we tell you which ones have been extended. So Norton Commons is one of those.
Well, Mr. McAuliffe also had a couple of things that he'd thrown up on the screen. memory just absolutely fails me. On things that we had not done,
Like,
yeah, neighborhood meetings, TRC and neighborhood meetings.
well, this is a plan unit development. The zoning map amendment requires a neighborhood meeting. I wasn't here when that PUD was brought before the planning commission, but I'm gonna assume that a neighborhood meeting was held back then. Subdivision plans and development plans do not require neighborhood meetings.
Okay? What about TRC?
Well, again, the expiration policy being extended and extended, we actually, the applicant has got agency letters. They've asked agencies for their responses.
Okay,
So they didn't go to the TRC, but we didn't, I, as the administrator, did not require them to go to the TRC.
okay. Okay, well, I just wanted to hear the rest of the story.
Okay, sure.
Thank you.
Anything else, sir?
No, sir.
Okay, Mr. King.
Thank you, Mr. Chairman. Jim, I'm afraid you're back on the spot. So one other assertion is made with respect to the construction of the lake, that it constitutes some violation of the PUD, the application.
Right, in section 230080, amendments to an approved master plan or development plan, under minor amendments, it clearly gives the administrator the authority to approve minor changes to the approved master plan or development plan. Minor changes include decrease in density and intensity, consolidation and shifting of lot lines, land use, and street modifications that would negatively affect adjacent properties. In the case of the retention lake, there was a request to construct the retention lake back in the latter part of 2016. It was looked at by MSD and by Oldham County Engineer at the time. And in my opinion, that's and also understand that generally speaking, the Norton Commons Development Plan or Master Plan considered that they would have to do some kind of detention or retention in order to deal with stormwater. And although it was part of mostly what was needed for the Jefferson County portion, we reviewed it and it was approved and it was bonded for construction. And so they never really said, well, this is where the lake is going to be. They knew and referred to in the master plan that there would need to be stormwater detention somewhere.
All right,
Generally speaking, in this area, because that's the lower part of the property.
and finally,
Mr. Chairman, Mr. King, I don't mean to interrupt, but if I could, Mr. Dominic would like to address that point just briefly as well about what was contained in our master plan.
all right, I got one more when
Okay, sure.
he's finished.
Go ahead, Mr.
That's fine.
Thank you.
Yes, sir, I heard that comment also, and in the original master plan from 2006, there's a section, of course, that deals with stormwater management. It's on page 37 of the report. There is a map that is included, and also some other tables and some representative data. But what we did at that time, not knowing, obviously, we're well in advance of wanting to do construction plans or anything, yet we knew there was a commitment to water quality and stormwater mitigation in this watershed. We put together this concept plan, and we indicated some key watersheds that needed to be some type of treatment, and we listed various options, whether they were, your typical dry detention basin, as you see a lot of times. Wet ponds are permitted. There were other green infrastructure items that were identified on here. And actually, the location of that pond is a key element to preserving what is really the Krieger Lake. It's a pond off-site that basically is just downstream of what we're trying to do. But the red arrow that's indicated on that plan clearly indicates this was an area where we intended to do some type of water quality treatment. Bear in mind, that was 12 years ago. And as developments moved up, we needed to do something. And that's where MSD, as we were completing various sections in the North Village. So that's prompted. This is in the right location. You know, geography notwithstanding, this is the right location to do that. And, you know, we actually probably ended up suffering an actual loss in lots too because of the location and the design of that pond. As I said, we oversized it. We made it much larger so that we could more effectively mitigate our runoff. But to say that it was never included as part of this plan is not true.
Okay. Thank you, sir. Mr. King?
All right, so finally, with respect to the stub road, and to whose property does this stub road attach?
It's the, what's referred to as the, thank you, it's what's referred to as the Fisher Farm.
The Fisher Farm.
That's correct.
Does your office have any record from the owners, of contact from the owners of the Fisher Farm with respect to potential connections on that property?
Well, there have been several people looking at developing that property.
Have the owners of the Fisher Farm come to you and advocated for particular configurations of stubs?
The owners have not, but the potential developers have.
Okay.
And that was a binding element, that there be a stub in that general location to allow interconnectivity between parcels,
Which is customary.
which is customary.
All right, that's all I have. Thank you.
Okay, Mr. Douglas, and then Mr. Finney. Oh, and Mr. Orton. Do you want to? No, go ahead.
I guess my question is to the applicant. My first one would be is, as far as the traffic study, there's been discussion on that. On the original 2005 master plan, PUD, the number of lots total for the hamlet was what?
257.
Say that again, sir.
I believe it was 257. It's whatever, it's the same as we are here about today.
That's my next question. The proposed lots for now this revised plan, which is just section 1, the total lots are still going to be 250 something?
Yes.
So the lot changes hasn't been made, correct?
No.
So the traffic study, I assume there was a traffic study done
Yes.
back in 2005.
Actually, probably prior to that, but yes, sir.
And I guess my comment or request would be, since there hasn't been any lot changes and additions, the same number of traffic that it was proposed in 2005 or earlier, although there's been tremendous growth around the area, we know that. But in realistic, you're not increasing the lot sizes or additional lots to increase traffic flow based on that. Is that correct?
That is correct, yes, sir.
Thank you.
And Mr. Douglas, just to go a little further, in the minutes from the December 13th, 2005 meeting, the county at that point had a consultant named Diane Zimmerman. Ms. Zimmerman testified about the traffic study that was performed. She testified there was no direct access points from the Oldham County portion to any roads in Oldham County. The traffic study performed was approved, and there's numerous improvements to Highway 22 in the process now due to this development. She recommended a connection of some type to an adjoining property to the north of Highway 61, i.e. the stub road, and that she went on further to discuss that. So it was reviewed at the time by the county's consultant. Ms. Zimmerman at the time was the county's consultant, and the number of lots proposed is the same number, and she reviewed that and had no other comments about it.
Okay. I had one other question, and I'm not sure who to ask or who maybe be able to answer it. Briefly, I believe someone on their presentation showed the agreement between MSD for the sewer capacity for the pump station that's already existing there. And there's some interlocal agreement between OSEA.
What was shown, and I have it, I can file it in the record. What was shown is the interlocal agreement. I apologize, what we have is a unsigned copy, but we believe this to be the approved interlocal agreement between Oldham County Sanitation District and MSD that dates back to 1999. There's an amendment to that agreement that was dated November 17th of 2016, which we do, I believe, have a signed version of that, and an approval letter from the Attorney General's office dated December 27th of 2016, discussing the approval of the interlocal agreement between those two agencies.
And just as clarification too, on the amendment, which was just approved in November of 2016, it does cite a February 11th, 2000 as the original agreement date. So
And that's basically that agreement is with OSEA, allowing MSD to take,
It is and I don't want to speak for them, so my interpretation, let's put it that way, is that this is an agreement that talks about interlocal cooperation between MSD and OSEA, where there is effluent treated, depending on the location, either by MSD or by Oldham County, when it would be more convenient, for example, for MSD to treat the effluent or Oldham County to treat the effluent. I'm sure aware that, for example, the city of Crestwood, even though they go past probably in some way the new OSEA plant, their effluent is treated by MSD.
correct. I was just trying to see if that agreement was based on the new plant that was built by OSEA.
Well, all I can tell you is there's a subsequent, after that plant was built, there's a subsequent ratification of the earlier agreements. And if I could, I'd file those in the record.
Okay.
Okay, thank you.
All right, let's see, Mr. Finney.
Yes.
Go ahead, I'm sorry.
Question again for the applicant. From the Oldham County section, school buses will be coming out onto not what is now Chamberlain Lane, is that correct?
They'd be on 1694.
Through Schuler Lane?
No, sir. There's no access to Schuler Lane.
Okay, so they'll be coming out onto another street, which would no longer be what is now Chamberlain Lane.
Well, it depends on how it's designed.
I mean, Chamberlain Lane off of 1694 is going to no longer exist. Is that not correct?
I think it no longer exists.
Well, there's still a sign there and still a road there.
Be careful about testifying, sir, Mr. Finney.
There are new connections through the property, but not Chamberlain Lane, no, sir.
Are they state width road connections or are they subdivision width road connections?
They are with road connections, probably 48 feet in the Jefferson County portion of this development.
Are you familiar with Highway 1694 from Schuler Lane to Highway 329?
Yes, sir.
How would you describe that as a drivable road for a school bus?
I don't have a description about that. I can assure you that many school buses travel on that section of roadway to get to north from Glen Oaks and Moser Farms on a daily basis when school is in session. This wouldn't be any different than that.
So we're coming out of a subdivision area of Norton Commons through narrow streets, working their way some way back to 1694 to get on a road that is,
Sir, and I wish I had control about that, but I don't work for the school board. I can't ask them to build a school in this area. And the issue is, it's the same issue for folks that live in Glen Oaks and folks that live in Moser Farms today. For their kids to get to school, their options are either they get on the Gene Snyder, go over to 42 and drive out through Jefferson County, or they get on Jefferson County roads, drive down 1694 over to 329.
has the Oldham County school system transportation portion done any studies or is aware of the?
I can't speak to what the Oldham County Transportation, what the school board has done about that.
Anything else,
Thank you.
Mr. Finney? Okay. Mr. Horton.
Thank you, Mr. Chairman. I'll wait a second.
Sorry.
Okay, thank you. I assume the residents will have access to all of the green areas, and will they have use of all of the green areas?
Yes, sir, and those are maintained by the Norton Commons Okay,
so that's the
in
parks
in
and the green
perpetuity.
areas. How about the lake?
Same.
Okay, will there be any fences that you know of around the lake or anything that's
Not that I'm
planned
aware
for
of, no.
that?
Wanted to know if the lake was gonna be fenced. No, sir.
Okay, thank you. Thank you, Mr. Chairman.
All right, any additional questions from, for either the applicant or the two gentlemen that spoke in opposition? Okay, seeing none, we will now move into rebuttal evidence and cross-examination by the applicant. Mr. Baxter, do you have any rebuttal?
I do, Mr. Chairman. I got to address a couple points. Mr. Turner raised a concern, and I guess I have to tell you I'm a little bit offended because he more or less called my client a liar about the number of students that are going to be generated by the 111 homes. And while that's just, I don't know how that number gets generated. But what I can tell you is we don't generate that number. That number is a number that Mr. Williams generates and that the Oldham County Board of Education generates. So the 36 students is not something that we picked up. It's not something we made up. That's the number that we were provided on the school board letter. If Mr. Williams were to come up here, I bet you he'd tell you that that number's probably going to be pretty accurate because this is something that he reviews on a regular basis to make sure that they are properly addressing the capacity. You all have maybe obliquely raised some issues about the school buses going through the neighborhood, about fire trucks going through the neighborhood, about emergency vehicles going through the neighborhood. Those issues exist in the existing Norton Commons. School buses drive through Norton Commons every day. Thankfully, fire trucks probably don't, but if they can get through there if they need to. Likewise, if we had an emergency, they can get through there. Those roads are designed to handle that type of traffic. Mr. McAuliffe has somewhat left you all with the impression that he is here representing a number of people. But I would remind you all that he is here by himself in his individual capacity. He is not an attorney, so he is here talking about his concerns, not the concerns of other folks who are not here today. He doesn't have the authority to represent those people, and he hasn't come forward with any legitimate complaints about any of those other people, and they aren't here today to complain. One thing about his proposed road that he'd like to see you all force my client to build through their property right there, I would note that he made a big deal about the waterfall. Well, the waterfall is fed by a stream that is going to go this direction, and his road that he wants to build is going to negatively impact that waterfall and that stream. So the two things that he's concerned about don't really seem to be in line with each other. And to ask my client to be responsible for building a road from here to here over property that that in parts they don't own, when nobody's come forth and said that they want this road on the other property owners, it is a little bit above and beyond something that you all, I think, are in a position to ask my client to do. I just would go back, we've gone through this process with them. In 2005, this got approved, and a master plan got approved. We came in today with a development plan that complies with that master plan. We are doing what we were asked to do. We have done everything that the staff asked us to do as it relates to that. We haven't hidden anything. We've been transparent in this process, and we will continue to be transparent in this process as we bring further phases of this development to you all. But we would ask you all to remember that that master plan is the guiding influence when you consider this particular project. Thank you.
Thank you, sir. All right, rebuttal evidence, cross-examination by, by the opposition.
Thank you for the opportunity to comment on Mr. Baxter's concerns. No personal concern addressed to any of you didn't call
I get you, sir, we need to get you on the microphone if you could.
I was going to apologize if I offended anyone. I believe my testimony was I challenged this board to challenge the assumption that was in the school board letter. That's what I said. I did not point to them and say anything about their integrity or their truthfulness in presenting this case before you. Okay, I want to make sure that's clear. Second thing I want to make clear, I am an attorney, and I am not representing anyone but myself and my wife. Okay, I am a member of the Hidden Creek Homeowners Association. I do not represent them in this matter, and I do not represent the board. Finally, the statement was just made that emergency vehicles can get through Norton Commons. What I ask you to do is evaluate how long it takes them to get through there. Not simply that they can get through there. The response time for a vehicle going through Norton Commons is going to be significantly reduced. Just common sense will tell you that. They have eliminated what was essentially a county road that was Chamberlain Lane. And all the things that they've asked for have benefited their subdivision, and it has a negative impact on the people that live around them because the traffic flow is all concentrated on 1694. There's no option other than 1694 and 329, as Mr. Finney pointed out. That's the only way. And those buses will have to come right to that intersection at St. Mary's and St. Bernadette's, where there's already traffic control at 7 o'clock in the morning to 7 till 9. So I just ask that you all take the time to investigate these things, these very important questions further. If you approve this today, we can't go back, and we'll never be able to put a road in like that that could mitigate the potential traffic problems. That'll be done because they'll build on top of it. That's why I ask for you to postpone any final vote on this and give these important and serious questions that will have a long-term impact and will be your legacy for the future if some kind of accommodation is not incorporated into these plans. Thank you.
Thank you. Mr. McAuliffe?
Is the clock correct?
I think so.
I didn't see it restart.
Did you restart it?
No.
Yeah,
It did? A couple things. First of all, I've been called a liar today. And that Mr. Dominic said that I was untruthful. And I want to say that the approved plan, that's the approved plan. That's the approved plan. Now, there's no lake there. Now, he brings out a stormwater plan. Is it the responsibility, I ask you, Mr. Dominic, is it the responsibility of the Planning Commission to approve stormwater plans? Is it the responsibility of the Planning Commission to approve stormwater plans?
Well,
It's not under your purview, okay? Now, if there's a map or something in there, that all is to go later. You are the only ones that approved this map. Now, I want him to show me evidence of the approved map where I'm lying that this lake was shown. Show me where this lake was shown on this approved development plan.
This is
we're
really
not in the
rebuttable.
Okay, I'm just saying, I'm trying to rebut testimony that I'm a liar. Okay, this actually shows both stormwater and sanitary sewer right there. That is the approved plan. If I could blow this up, you could see where stormwater goes. You could see also where they showed. Both this is a conceptual stormwater and sanitary sewer. Mr. Urban, when it's asked about the expiration of, and whether or not we have a TRC, and I can only go back to what this, next, can you put this image up? Okay. I can only go back to what the Oldham County Comprehensive Zoning Ordinance says. That's all you can do. And it says that it only has 24 months. It says you can get one extension. It says you can get another 2 subsequent 12 months extensions. That's it. Doesn't matter. You can give the Planning Commission, give Mr. Urban whatever, and say you do whatever, but that's what the zoning ordinance says. You got to follow the zoning ordinance. Unless it's changed, that is it. The other issue is you have to follow our zoning ordinance. Technical Review Committee. After approval of a master plan and zoning map amendment, a development plan shall be submitted for review accompanied by a filing fee. Item 1, Technical Review Committee. Plans shall, for the entire PUD site or any one phase, shall be submitted for review. Technical, you cannot assert that. Now, those are items where, and I'm sorry, Mr. McWilliams, that you couldn't follow me. In the middle of my testimony, I was urged to move on by the chairman. We had 20 minutes still left on our time when I finished. We had 18 minutes left on our time. So I was being interrupted. Now, so I can only say, go back, and I'm not asking Norton Commons to put any kind of road and build a road on other people's property. That's pretty much a statement that I'm gonna say I was only saying that we were looking for a study area and get a study so we can understand how this area is gonna grow in the future. And I believe that this plan, if it's approved today as it is, which is, I believe it cannot because it's not complied with the zoning ordinance, which says you should have a TRC, number one. And number two, they've deviated from the plan. They built a stormwater basin that is not on the map. And if that basin was discussed in a stormwater management plan, that wasn't in front of this body. So, I only can say is I've been an honest person with you all, always. I've never misled anyone.
Your time has expired on the rebuttal, but you do have 5 minutes on a final statement, so you
Thank
can
you.
continue if you would like to. Yes, Bob, you have 5 minutes if you want for a final
I'm
statement.
sorry.
No, your time on rebuttal had expired, but there's a 5-minute time for a final statement. So between you and Mr. Turner,
Okay.
you can.
Well, obviously, there's a bunch of people who have been in here all day
Right.
for another case, and so I don't want to belabor the point. I think I've made all my statements, but I just want to say that the Planning Commission, again, you all have to follow our ordinances. And no one has shown to me today that this is not what should have been done. What both of these say, that's the expiration of benefits, of the opportunity. Doesn't matter about it doesn't matter how long, it just says, that's it, 5 years. It's been a long time that this plan was approved. I think it should have gone through a TRC. It may need to go back. I think the neighborhood, everybody should get together. Let's come up with a plan that works. I'm supportive of the Norton Commons, have been from day one. Excellent developer. I'm sorry it got personal. My neighbor was accused of being a liar. I was accused of being a liar. We are not lying in front of you guys today. We're just stating the facts. So I think, and it's also, it also says that if the developer submits a plan that is not in accordance with the plan that was approved, if the commission finds that the development plan is not in compliance with the master plan, if it's not in compliance, the applicant may, one, revise the development plan to comply with the approved master plan, or B, apply for an amendment to the master plans. They've not come here in front of you today and asked for amendment or change plans. They put a lake in front of, and they unilaterally, cavalierly. And they went to we were with the county engineer. We didn't have a county engineer when they got the stormwater lake approved. We did not have a member on staff when that took place. And Mr. Urban was acting as, in the letter, they evidenced this letter, but he was acting as issuing the approval. And so I think that at that time, and also our MS4 Phase 2 program, we were hiring a new engineer, was coming on board. And it's clear also, most of this water is coming out of Jefferson County. Jefferson County, just as a sidebar, I've talked to the judge about this, we have missed an opportunity. MSD's collecting the $35 or $40 a month on each household, but it's coming to the structure was built in Oldham County. We charge our residents for a fee annually, $75 or whatever your thing is. But ultimately, the point is that our community now forever has to monitor and watch that MS4 basin. And this is a very dense development, massive amount of stormwater. There's not a more dense development in all of Oldham County, or most likely Jefferson County, unless you went to downtown. So, but anyway, thank you all very much, but I'm sorry it got personal. Thank you all.
All right, thank you. Mr. Turner?
Yeah. I just want to ask all of you to carefully consider the many unanswered questions about how this approval will impact the surrounding area and all the other residents of Oldham County who drive on 329 and 1694 on a routine basis. The traffic now is insufferable at times. I challenge you to drive through this subdivision and judge for yourself before you vote on this. It's just too important. The impacts that were estimated in 2005 before over 40% increase in population in Oldham County cannot be the basis of a decision today. It just isn't reasonable to use numbers that are 12 years old for traffic studies. And Mr. Finney challenged Mr. Baxter on this issue, and he admitted those traffic studies might have even taken place before 2005. Now, I realize I don't have a lot of time. I don't frequent planning and zoning meetings very often. But this is an important issue. This is larger than just Norton Commons. This is larger than just the people who live down Schuler Lane. It's about the future of Oldham County in a very critical, sensitive area that all of you need to be aware of, critically aware of, before you make a decision on this submission. And I ask that you do that. And thank you very much for your attention.
Sir? All right, Mr. Baxter, 5 minutes for closing.
Thank you, Mr. Chairman. Ladies and gentlemen, I appreciate your time today. Again, I go back. You know, my client in 2005 was before this body and had a master plan, planned unit development approved by this board that gave detailed instructions about what they were going to do going forward. There was issues raised at that time about stormwater, about sewer, about water, about how all of these services were going to get to this piece of property. We show up for a hearing today after being told that we didn't have to go to TRC, that if we could get updated agency letters, that that was acceptable, and we did that. We have agency letters that indicate the availability of the necessary services to serve this piece of property just like they had in 2005. And we are here with a plan that follows that master plan, asking you all to approve what we are asking you to do. I went back, I looked at the minutes from 2005, and Mr. McAuliffe was present at that meeting, and he had some concerns at that meeting. Mr. Turner had told you all that he has lived in this subdivision for 33 years. He didn't come to that meeting and complain at that point. When there was neighborhood meetings, when there was things that were raised at that point, he had an opportunity to come in and raise these questions that they are now raising before my client spent $800,000 making sewer improvements, before my client spent a large amount of money improving Highway 22 and making intersection improvements according to what the Kentucky Highway Department told us we needed to do. They have done the groundwork to be in a position to develop this piece of property. They are here with a plan consistent with their master plan, and they aren't asking for anything departing from the original plan that they came in with. The lake that we're talking about was something that went through the planning office. Mr. Urban is well aware of the process that went into that, putting that lake on the plan, and Mr. Urban has told you that this is a land use issue, which is something that he has the authority to approve. It's not a departure from the plan that we submitted in 2005, and we would ask you to review this plan in light of the master plan, find that it in fact conforms with the master plan, and approve our development plan. Thank you.
Sir? All right, with that, docket PZ 17028 is completed. And I'll ask Mr. Urban if you would outline, as always, what's being requested.
Approval of the development plan.
Okay.
I'm sorry. I've got so many papers. Give me a second.
All right.
I've got a bunch of things.
Your mic's not on.
There are a number of things that I almost want to say, but it would almost open this back up for discussion again and potential rebuttal. And I'm remiss that I,
Yeah, I think we need, I mean, you need to stay on point as to what's, requested in this particular application on the planned unit development plan.
okay. So what you have in front of you, if you agree that there have not been significant departures from the previously approved master plan, is a request for a development plan, either to recommend approval, or not recommend, but either to approve or deny. And there are proposed binding elements in your staff report, with one change from what I've heard of, actually presented by Brooke at the beginning of this hearing. The first binding element is that there will be no changes to the development plan without review by the Oldham County Planning Commission. The second is the cumulative phasing shall limit the number of building permits issued to 40 per year beginning the first record plat. The third, which is one that's going to be modified in your staff report, is that all street trees and landscaping, including those in the right-of-way, shall be maintained by the homeowners association in perpetuity, even if removed or damaged by the county during maintenance of the right-of-way. And then a fourth one would be location of the street trees are to be reviewed and approved by the county engineer and planning staff. And number 5, the development plan must comply with all established state and county ordinances and requirements at the time of approval. I don't think I've heard any other potential binding elements.
Okay. Mr. Carter, anything else that needs to be added? No. All right, Chair will now entertain a motion on docket PZ 17028. Oh, I'm sorry. Mr. Horton.
Motion?
Oh, okay, I'm sorry. Yes, go ahead. Yes, sir.
Give this a stab here.
Your
I
mic
think,
on?
yeah,
Okay, sorry.
I'll just talk louder. I think the motions for the PUDs are somewhat different from some of the other motions we've had. So I'd like to make a motion to approve the PUD development plan docket PZ 17-028. I find that it complies with the objectives of the comprehensive plan in several ways, as it's itemized in what they have labeled their plan report, as well as that in the master plan. I think it complies as it's required to do with Division 230 of the zoning ordinance, and specifically Section 230-010 when they talk about the intent and purpose of a PUD. It also has none of the 22 listed prohibited uses. It complies with the planned unit development future land use category of the comprehensive plan, and the application also complies with consideration and planning for many kinds of probable impacts on sewers, roadways, et cetera, et cetera. I think as a PUD, it provides substantial benefit to the community and even in the environment. The PUD letter PUDs are better planned, they contain more amenities, they're usually a more desirable place to live and work in an area. And I think they also have complied with looking into the areas of utilities, of adjacent properties, of density of land use, and all of that is in their plan report. So I make the motion to approve, and along with the binding elements in the staff report and those of Mr. Urban.
Mr. Carter, is that adequate motion, sir?
Yes.
All right, do we have a second? Ms. Smith seconds. All right. Any discussion on the motion to approve the development plan on Norton Commons for the planned unit development plan? Double negative. Anyway, it would be a motion to approve. Yes, sir, Mr. McWilliams.
Mr. Chairman, as part of the discussion, would I be allowed to ask Mr. Carter a couple of questions?
Certainly. Yes, he's our attorney.
There you go.
Mr. Carter?
Carter?
Are you my nemesis today?
I am, sir. That is not personal. Are you comfortable as our attorney that we have not violated some of our own ordinances, as some have suggested that we did?
The planning commission has to approve an extension for a subdivision to be built past the time that it was originally approved. If there is a record somewhere that says the planning commission authorized staff to extend the time without planning commission approval, I believe that would be okay legally.
Thank you. And that's,
What, you have another question?
yes, sir, I do. And this has to do with the master plan
Yes.
that we've been talking about. Are there circumstances that you're aware of where you would be allowed to deviate from that master plan?
Not,
Go ahead.
well, it depends on what you mean by deviate. We have always required subdivision developers to come back with their development plan when they change the number of lots, or either increase or decrease the number of lots.
Right.
That's not happened in this case. The question is the lake is not on the development plan. If the lake indeed is only for watershed purposes, I think that the county engineer could have approved that. I don't know that. I would have to know that if it's a recreational lake, I'd say no. It needed to come back to the commission and get the commission's approval for to change the development plan. But if it's just stormwater drainage, I would say that the county engineer would have had that prerogative to approve it where it is. But I don't know that.
Mr. Urban, you want to add something to that?
I do. At the time of the request to construct this retention lake, our county engineer at the time was on medical leave. And the county had hired an engineer to provide all the technical and necessary review of development plans. That person under contract, Milburn, received, as I did, a packet with stormwater calculations regarding this retention lake, and reviewed those and actually recommended some changes, or some additional information, rather, in terms of what he saw and reviewed. At the same time, MSD reviewed all those stormwater calculations. And even though it was in Oldham County, they reviewed and stamped the plans, knowing full well that it was in Oldham County, and then relinquished the ability to bond that as a stormwater feature, not as a recreational lake, to Oldham County, which we did. And I talked to the people at MSD, and as the administrator with the only authority to approve anything at the time, but having been reviewed by the consulting engineer, and once he was satisfied with the requirements, then I approved the plan for a retention lake.
Mr. Urban, Mr. Chairman, Mr. Carter, I didn't hear anything I didn't expect to hear, but I think it's important that all the commissioners hear from our leadership that we are doing things the way we're supposed to do things. There may be some extenuating circumstances, but under those extenuating circumstances, we're doing the best that we can do. So I'm satisfied.
Thank you, sir.
Thank you.
All right, I think, Mr. Horton, did you have your hand up for discussion?
Yeah, thank you. You calling on me?
Yes.
Okay,
Yes,
good.
I'm sorry.
Yeah, thank you. If it's not a recreation lake, the way I look at it, then you've mentioned a retention lake. If it's a retention lake, we've already been shown on the original plan an arrow indicating where the retention lake or retention pond, or whatever you want to call it, would be. And that is in the position where this body of water is now. So if it's not a recreation lake, then it's a retention lake, and they have plotted that on the original plan.
All right, any further discussion for Mr. Finney? I'm sorry.
I just have a question on how we can accept a 12-year-old traffic study as being valid, especially with the changes we've seen here. And we just basically have gone through the same thing with over the bypass over in Crestwood. I mean, there all that was built, that's as modern as it gets, and it's already being shown as inadequate. So we have a road system over on Highway 1694 and Chamberlain Lane that are very, very old, have been there, you know, basically unchanged in width much since the 1950s. And now we are dumping tremendous amount of extra traffic and school traffic on these roads, on dangerous roads, not roads that are nice and straight and level, but dangerous roads. And I think we've missed by not having these people require a traffic study that's up to date. It just needs to have and in your motion, Mr. Falvey, you said that they had met these traffic requirements. I don't see how they can. It hadn't been looked at for over 12 years, at least. And so there's a problem there. I don't know if amending the motion is the proper thing to do. I don't know if we have the proper information to approve it, because we've got a way outdated traffic study,
Well,
and that affects schools and everything.
without offering testimony, I'm going to refer back to Mr. Bagster's rebuttal statement or closing argument, where he referred to the Oldham County traffic engineer having conducted a traffic analysis when this was approved. And it's a good question to ask, because if you are planning for these improvements, are you in theory kind of granted, like when you pay sewer capacity, or when you have a plan that's approved and they say, okay, we have plenty of sewer capacity, but then somebody else comes in and develop, can we take away sewer capacity? Can we take away road capacity? And you know, I think we did have an adequate review at the time. As required by our regulations.
On school capacity, excess, and being in excess school capacity is a reason to deny. Isn't that not correct? You can deny development because of lack of school capacity in an area?
Well, but I think had testimony on the letter that we received from the school board that showed they had plenty of capacity on this development.
2005.
No,
I'm
now.
talking about now. This just came in yesterday or day before.
Well, the school, yes, on school capacity, but this still does not address getting the kids to and from school. And that's where the problem lies. Getting the children to and from school on inadequate, overcrowded roads. That's the problem. It's just like we're running into with the development there at Crestwood. The roads do not match the demand. And these roads over here seriously do not match the demand. So, to me, a 12 or more year outdated study is not valid.
All right, well, let's, is there any further discussion before we?
I call for the question.
Okay. All right, let's go ahead, the question's been called, and let's, the motion on the floor is to accept or adopt, or approve the plan unit development on Norton Commons Hamlet.
Development plan.
Development plan, I'm sorry, on Norton Commons Hamlet on docket PZ 17028. So, Ms. Fox, and this is a motion to approve. So if you would, let's do the vote.
Mr. King,
Yes.
Mr. Klingenfuss,
Yes.
Mr. Metzger,
Yes.
Mr. McWilliams,
No?
Mr. Neal,
Yes.
Ms. Smith,
Yes.
Ms. Bonet,
Yes.
Ms. Crosby,
Yes.
Mr. Falvey,
Yes.
Mr. Finney,
No.
Mr. Hampton,
No.
Mr. Douglas,
Yes.
Mr. Horton,
Yes.
All right, the motion to approve on docket PC 17028, the development plan on Norton Commons Hamlet has been approved on a vote of 10-3. All right, commissioners, do you all need to take a recess before we move into our last two docketed items?
Probably need time for people to get in.
Okay, let's take about a 10-minute recess here and get everybody settled back in.
One more. Oh, we just had one more. Oh, we just had one more.
No, it's the same thing.
It's at Edwards, at apartment. One's the zoning change, the next one is the